Record will reflect the presence of counsel, the defendant, and our jury. So first things, as we explained, and I'll talk about more when I instruct you, delays can occur. Let me just explain. It's not the attorneys. As I explained earlier, I happen to be the duty judge this week. Every 6 weeks, we're duty. And as I explained, I have no control over this 8:30 calendar. We had 7 initials this morning, and I even handled a couple things yesterday afternoon so they wouldn't be on that calendar. So we did our best, but we were on the bench for almost an hour, starting at 8:30, and I needed to give Dahlia a break before we started the instructions. So I apologize that I kept you all waiting, but I just wanted you to know the reason why. All right, the good news is, I don't think I'm duty, maybe one more day while we're in trial, so hopefully this issue won't come up again. Okay, let me do this. I know I've previously read the charges to you before, but I am required to do it again before I read you the preliminary instructions. And just as a reminder, thank you for wearing your badges today. The notebooks, Mike, I can't remember if we already put them in the notebooks or we just gave them to him, but okay. So you can see that there are 3-hole punched, I think. My judicial assistant tries to do that for you. So you can just put those right into your notebook. And those are your instructions. And I'm gonna read them to you in a few minutes because I have to read them to you. It's called instructing you. You can follow along if you want to as I read them to you. Can everybody hear me okay? Okay, now remember what I was saying before, earlier in the week. This is really critical. It's very important that you all hear and see everything when anyone's speaking in the courtroom. And so if at any time you can't hear or see something, please get my attention or the bailiff. You can absolutely interrupt us. You'll see I keep a good eye on you, and I hope you don't think I'm not staring at you, but I keep an eye, make sure everybody's alert and everybody's doing okay and no one's having any sort of discomfort. You know, maybe somebody needs a restroom break or something like that. So I try to keep an eye on you. But again, if you can't hear or see something or you need a break, you're in some sort of distress, just let us know. One other thing I want to let you know is in a little bit, I will have my laptop up here. I just want you to know the reason I have my laptop up here is we've gone to electronic filing with just about everything I'm assigned. And so instead of, sometimes paper files come up, but really what we're seeing now is electronically things are filed. And so sometimes I've got to be looking at my computer at the same time. I'm very careful when I multitask. I can't multitask a whole lot when I'm in trial, but sometimes I can. And it's also the way I communicate with my judicial assistant. If we need something or she needs to tell me something on a case, then I can look at my email when I get a chance, and it's safe for me to do that, and I communicate with her that way. I'm telling you this because I don't want you to think I'm not paying careful attention. I absolutely do. And I'm not surfing the internet. It's a work-related function, why the laptop is up on the bench. Okay. I'm now going to advise you of what the defendant has been charged with in this case. The state has charged the defendant as follows in this case. Count 1, first-degree murder. The state alleges that Mark Daniel Gooch, on or between January 18th, 2020 and January 19th, 2020, allegedly intending or knowing that his conduct would cause death with premeditation, did cause the death of Sasha Marie Krause. The state has also charged this same count in the alternative as follows. State alleges that Mark Daniel Gooch, allegedly on or between January 18th, 2020 and January 19th, 2020, acting either alone or with one or more other persons, committed or attempted to commit kidnapping, and in the course of and in furtherance of such offense or immediate flight from such offense, Mark Daniel Gooch or another person did cause the death of Sasha Marie Krause. Count 2, kidnapping. The state alleges that Mark Daniel Gooch, on or between January 18th, 2020 and January 19th, 2020, knowingly did restrain Sasha Marie Krause with the intent to inflict death, physical injury, or a sexual offense on her, or to otherwise aid in the commission of a felony. Count 3, theft. State alleges that Mark Daniel Gooch, on or between January 18th, 2020 and January 19th, 2020, allegedly without lawful authority, knowingly did control Sasha Marie Krause's head covering and her underwear of a value less than $1,000 with the intent to deprive Sasha Marie Krause of such property. The defendant has entered a plea of not guilty to each and every charge. All right, I'm now going to instruct you on the preliminary jury instructions. Again, if you'd like to follow along with your individual copies, you certainly may do so. Let me tell you why you're hearing beeping, because you might wonder, and I don't want you wondering. So there, on the phone here on the bench, there are some people, including family members of the parties in this case. Well, I'll just say people interested in the case and want to be able to hear what's going on in court. So that's why you're hearing beeping. It's people either joining the phone line or disconnecting from the phone line. They're told to mute themselves. But I hope you don't find that as a distraction. But that, you can see there's only so much room in the courtroom, and for people interested in the case that may have a connection to it in some way, want to be able to hear what's going on. Yes, you may. So counsel was just telling me, because the county has these phones throughout the county, I think, but I've got another, it's called a biamp system. I'm going to turn the volume down on this biamp, Patty. I'm talking to Patty's here today. Crystal will be here in the afternoon, my judicial assistant. I'm going to turn the volume down on the biamp, Patty. If you'd let Jared know, Jared's our IT person, to hopefully minimize how loud these beeps are coming on the phone. And if people on the phone, this is Judge Nichols, if you have trouble hearing, then you might want to disconnect, call back in, and let my judicial assistant know you're having trouble hearing, and we'll get the volume back up. Okay. But counsel believes that I can turn the volume down on my end and it won't affect your ability to hear. Hopefully that's correct. Okay. All right. Jury service is an important part of our system of justice with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience or worse, jury service is an important responsibility for you, and one which I am sure you will all take seriously. Ladies and gentlemen, now that you have been sworn, I will briefly tell you something about your duties as jurors and give you some instructions. At the end of the trial, I will give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from the evidence produced in court. You must not speculate or guess about any fact. You must not be influenced by sympathy or prejudice. You will hear the evidence, decide the facts, and then apply the law I will give to you to those facts. That is how you will reach your verdict. And I'm going to just say verdicts because you saw that there's more than one count. In doing so, you must follow that law whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion about the facts. You and you alone are the judges of the facts. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents and other things received into evidence as exhibits, and any evidence stipulated to by the parties or that you are instructed to consider. You will decide the credibility of the witnesses and weight to be given to any evidence presented in this case, whether it is direct evidence or circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise actually perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be determined. The law makes no distinction between direct and circumstantial evidence. You must decide the weight to be given to all the evidence without regard to whether it is direct or circumstantial. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. As I mentioned earlier, it is your job to decide from the evidence what the facts are. Here are 6 rules on what is and what is not evidence. 1, evidence to be considered. You must determine the facts only from the testimony of witnesses and from exhibits admitted in evidence. Anything you may see or hear when the court is not in session, even if what you see or hear is done or said by one of the parties or by one of the witnesses, is not evidence and must not be considered by you. If you should hear or see anything pertaining to the case outside the courtroom, or if anyone should attempt to speak to you about this case outside the courtroom, please report it to me as soon as you can. 2, lawyer statements. Statements or arguments made by the lawyers in the case are not evidence. Their purpose is to help you understand the evidence and law. 3, questions to a witness. A question is not evidence. A question can only be used to give meaning to a witness's answer. 4, objections to questions. If a lawyer objects to a question and I do not allow the witness to answer, you must not try to guess what the answer might have been. You must also not try to guess the reason why the lawyer objected in the first place. 5, rejected evidence. At times during the trial, evidence may be offered that I do not admit as evidence. When evidence is not admitted, you must not consider it for any purpose. 6, stricken evidence. At times, I may order some evidence to be stricken from the record. Then it is no longer evidence, and you must not consider it for any purpose. Admission of evidence is governed by rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. If an objection to a question is sustained, you must disregard the question, and you must not guess what the answer to the question might have been. If an exhibit is offered into evidence and an objection to it is sustained, you must not consider that exhibit as evidence. If testimony is ordered stricken from the record, you must not consider that testimony for any purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility of the witnesses or the weight you should give to any evidence that has been admitted. The rule of exclusion of witnesses is in effect in this trial and will be observed by all witnesses until this trial is over and a result announced. This means that all witnesses will remain outside the courtroom during the entire trial, except when one is called to the witness stand. They will wait in the areas directed by the bailiff unless other arrangements have been made with the attorney who has called them. This does not apply to the defendant or the victim's family, or to, for example, the case detective, what we call the case agent with the state, Detective Noggle, and it doesn't apply to Mr. Robertson, the defense investigator that may be back at counsel table that you've seen already. Now, the rule also forbids, and let me just say, the folks I just mentioned have the right to be present during the proceedings. Okay, now this rule of exclusion also forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. The lawyers are directed to inform all their witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witness from remaining in the courtroom if they accidentally enter. From time to time during the trial, it may become necessary for me to talk with the attorneys out of the hearing of the jury, either by having a conference up here at the bench when the jury is present in the courtroom, or by calling a recess. Let me also add, you've already seen, I also do bench conferences with the lawyers right in my judicial assistance area there, because that way I don't have to take you in and out of the courtroom. And I think overall that's easier on you folks, so that's why I do that. Now, please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or of what your verdicts should be. Please do not be concerned with what we are discussing at any bench conference that we may have. Please respect the privacy of those participating in the bench conferences in order to maintain the fairness of the trial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may not, I apologize, I misspoke, so I'm striking what I said you may not. Let me back up. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in light of reason, common sense, and experience. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise, and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You will not be given a written transcript of any testimony. You should pay close attention to the testimony as it is given. You have been provided with notepads and pens. The court encourages you to take notes during the trial if you wish to do so. Do not let note-taking distract you so that you miss hearing or seeing other testimony. You may use your notes during your deliberations at the end of the trial. Until then, keep your notes to yourself. During recesses in the trial, you may leave your notes, which in your and I'm talking about your notebooks too. You can leave them on your seats if you like during recesses. You can also take them with you to the jury room, our jury room, where your jury rooms where you're meeting before we bring you in for court. Now, your notes are confidential, and my bailiff will guard them. No one will be allowed to read your notes. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of other jurors. After you have rendered your verdicts, the bailiff will collect your notes and destroy them. Do not be influenced at all by my taking notes at times. What I write down may have nothing to do with what you will be concerned with at this trial. I'm now going to say a few words about your conduct as jurors. I'm going to give you some do's and don'ts, mostly don'ts, which I will call the admonition. Remember, I told you I was going to go into way more detail? Well, here's the detail about the admonition. Do wear your juror badges at all times in and around the courthouse so everyone will know you are on a jury. Each of you has gained knowledge and information from the experiences you have had prior to this trial. Once this trial has begun, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case on your own. Do not view or visit the locations where the events of the case took place. Do not consult any source such as a newspaper, a dictionary, a reference manual, television, radio, or the internet for information. If you have a question or need additional information, submit your request in writing, and you'll give it to the bailiff, and who will give it to me, and I will discuss it with the attorneys. Now, one reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts you find. As I previously told you, the only evidence you are to consider in this matter is that which is introduced in this courtroom. The law that you are to apply is the law that I give you in the final instructions. This prohibits you from consulting any outside source. Do not talk to anyone about the case or about anyone who has anything to do with it. And do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, MySpace, Twitter, instant messaging, BlackBerry messaging, iPhones, iTouches, Google, Yahoo, or any internet search engine, or any other form of electronic communication for any purpose whatsoever, if it relates in any way to this case. This includes, but is not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case or your courtroom experience with anyone whatsoever until the trial has ended and you have been discharged as jurors. Until then, you may tell people you are on a jury, and you may tell them the estimated schedule for the trial, but do not tell them anything else except to say that you cannot talk about the trial until it is over. Remember, if you have a question or need additional information, submit your request in writing, and I will discuss it with the attorneys. It is your duty not to speak with or permit yourselves to be addressed by any person on any subject connected with the trial. If someone should try to talk to you about the case, stop him or her or walk away. If you should overhear others talking about the case, stop them or walk away. If anything like this does happen, report it to me or any member of my staff by calling my judicial assistant at, and that's the number I gave you yesterday. That number goes right to their desk, 928-679-7557, and report it to them as soon as you can. And by the way, you can also report it to the bailiff, Mr. Wildermuth. All right, okay. To avoid even the appearance of improper conduct, do not talk to any of the parties, the lawyers, the witnesses, or media representatives about anything until the case is over, even if your conversation with them has nothing to do with the case. For example, you might pass an attorney in the hall and ask what good restaurants there are downtown, and somebody from a distance may think you are talking about the case. So again, please avoid even the appearance of improper conduct. The lawyers and parties have been given the same instruction about not speaking with you jurors, so do not think they are being unfriendly to you. When you go home tonight and family and friends ask what the case is about, remember, you cannot speak with them about the case. All you can tell them is that you are on a jury, the estimated schedule for the trial, and that you cannot talk about the case until it is over. In a civil case, the jurors are permitted to discuss the evidence during the trial while the trial progresses. In a criminal case such as this, however, the jurors are not permitted to discuss the evidence until all the evidence has been presented and the jurors have retired to deliberate on the verdict. You therefore may not discuss the evidence among yourselves until you retire to deliberate on your verdict. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you have had an opportunity to discuss the case with each other in the jury room at the end of the trial. Before each recess, I will not repeat this entire admonition I have just given you. I will probably refer to it by saying, please remember the admonition or something like that. However, even if I forget to make any reference to it, remember that the admonition still applies at all times during the trial. There may or may not be news media coverage of the trial. What the news media covers is up to them. If there is media coverage, you must avoid it during the trial. If you do encounter something about this case in the news media during the trial, end your exposure to it immediately and report it to me as soon as you can. Now, we know there are cameras in the courtroom, so if there are cameras in the courtroom during the trial, do not be concerned about them. Court rules require that the proceedings be photographed and or televised in such a way that no juror can be recognized. If at any time during the trial you have difficulty hearing or seeing something that you should be hearing or seeing, or if you get into personal distress for any reason, raise your hand and let us know. If you have any questions about parking, restaurants, or other matters relating to jury service, feel free to ask one of the court staff. But remember that the admonition applies to court staff as it does to everyone else. So do not try to discuss the case with court staff. If you have a question about the case for a witness or for me, write it down, but do not sign it. Hand the question to the bailiff. If your question is for a witness who is about to leave the witness stand, please signal the bailiff or me before the witness leaves the stand. So let me talk a little bit about this. I don't know, quite frankly, if all states allow this, but in Arizona, jurors are allowed to ask questions of witnesses. So this is what I'm talking a little bit about here, and this is how it works. You're going to see the attorneys question the witnesses. When they're done questioning the witness, each and every time, I will ask you jurors, do you have any question of the witness? If you do, there's forms in your notebooks that say juror questions. So write your question down. Do me a favor, try to be legible because I've got to read it. If we do ask the question, we read it the way it's written. So make sure that your handwriting's legible. So we're not. The attorneys and I are not trying to figure out what the word is. But you'll write your question down. Do not sign your name. And then you're going to hand it to the bailiff. Again, as trial gets going, you're going to see how this works. So you're going to hand the question to the bailiff. The attorneys and I will review the question. And I'll talk more to you about how this works. Now, one thing I want to remind you of, because I've had this come up with jurors, you're going to get one period of time where you can ask questions of the witness. So let me explain. So let's say you have a couple questions, or maybe there's just one question from one juror. And let's just say the question's asked. The way it works is I then give the attorneys follow-up. They get to ask follow-up questions. But then once they ask the follow-up questions, then that witness is done, the witness is going to get excused. I've had jurors try to ask more questions after the attorneys do their follow-up, and it just doesn't work that way procedurally. So you're going to get this one window of opportunity to ask the witness a question. when I ask you. And you'll hear me after you may have one or two questions. I'll say again, any other questions for this witness? Because I can't, that's your one time. That's your one time. Because once I turn it over to the attorneys for follow-up, you cannot ask any other questions of that witness. You'll see how this works as we move along in the trial. Okay. So if you have a question, the lawyers and I will discuss your question. Now, the rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question and the answer is available, an answer will be given at the earliest opportunity. When we do not ask a question, it is no reflection on the person submitting it. You should attach no significance to the failure to ask a question. I will apply the same legal standards to your questions as I do to the questions asked by the lawyers. If a particular question is not asked, please do not guess why or what the answer might have been. The law provides for a jury of 12 persons in a case such as this. As you can see, we have more than 12 of you in the jury box. And the reason we do that is so if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, the alternate jurors will be determined by lot in a drawing held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of the case. A defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. The state has charged the defendant with first-degree murder, kidnapping, and theft. These charges are not evidence against the defendant. You must not think the defendant is guilty just because the defendant has been charged with these crimes. The defendant has pled not guilty. The defendant's plea of not guilty means that the state must prove every part of the charges beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, then you must give him the benefit of the doubt and find him not guilty. In deciding whether the defendant is guilty or not guilty, do not consider the possible punishment. The trial is expected to last, as I know I've already told you, no later than through Friday, October 8th, 2021. That's when the attorneys expect we'll get the case to you for deliberation no later than that date. Now, we will all do our best to move the case along, but delays frequently occur. These won't be anyone's fault, so please don't hold them against the parties. Delays usually occur because the attorneys and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I am busy with matters in other cases. The usual hours of trial will be as follows. So you'll see that Tuesday and Wednesday, and Thursday schedules were listed. Since we're now on Friday, I'm just going to pick up with Friday if that's okay. So today, Friday, September 24th, 9 a.m. to 4 p.m. Then next week, Tuesday, September 28th, 2021 through Friday, October 1st, 2021, the schedule is 9 a.m. to 4 p.m. Then the following week, Tuesday, October 5th, 2021 through Friday, October 8th, 2021, again, 9 a.m. to 4 p.m. schedule. Now, as I've already told you, we'll take short recesses about every mid-morning and mid-afternoon. And actually, I'll just tell you, it's basically every hour and a half. I've got to do that for you, and I've got to do it for Dahlia, most importantly, but also for the attorneys and the court tech and the parties and myself. Occasionally, stretch breaks in place, but remember, every time we're having a bench conference outside your presence and you're there in your chair in the jury box, those are great times to get up and move around and stretch, and you don't need permission to do that. And I will tell you also, during the trial, if any of you feel like, gosh, testimony's happening, but if I could just stand up and just stretch for a minute, that's okay. You can do that. All right, we will recess at 12 noon and begin again at 1:30 p.m. Unless a different starting time is announced prior to recessing for the evening, you may assume a starting time of 9 a.m. for the next day. At the beginning of the day, please assemble in the jury rooms. And I'm saying jury rooms because we're trying to separate you out with COVID and give you more space. So right now we're using 2 rooms, I believe. Where Mike went. Mike, yes, right, we're using 2 rooms. Luckily, we've got the ability to do that. So you'll go to those rooms every morning when you come to the courthouse, and after every break, lunch break, So at the beginning of the day and every time you're coming back from a break or lunch, please assemble in that jury room for the jury rooms for our division. And please do not come back into the courtroom until the bailiff calls you. He'll physically bring you in each and every time we're ready for you. Now, criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement, giving you a preview of the case. The defendant's attorney may make an opening statement during the defense case immediately after the prosecutor's statement, or it may be postponed until after the state's case has been presented. What is said in opening statements is not evidence, nor is it an argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Second, the state will present its evidence. After the state finishes the presentation of its evidence, the defendant may present evidence. If the defendant does produce evidence, the state may present additional or rebuttal evidence. With each witness, and I'm talking about when they're on the witness stand, with each witness there is a direct examination, a cross-examination by the opposing side, and finally, redirect examination. It's after that redirect examination is when I'm going to ask if you have any questions of the witness before they leave the witness stand. And then, so this is a standard instruction. This says this usually ends the testimony of that witness. But remember, again, the way it works is direct examination, cross-examination, and redirect examination. I then ask if you have any questions, and after I find out, I confirm no more questions from the jury, then the attorneys get to do follow-up, and then that ends the testimony of that witness, and that witness will be excused from the witness stand. All right, third, after all the evidence is in, I will read and give you copies of the final instructions, the rules of law you must follow in reaching your verdict. Fourth, the attorneys will make closing arguments to tell you what they think the evidence shows and how they think you should decide the case. The state has the right to open and close the argument since the state has the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Fifth, you will deliberate in the jury room about the evidence and rules of law in an effort to reach the verdicts. If you unanimously agree upon the verdicts, they will be read in court with you and the parties present. And then finally, you will be discharged and released from the admonition. The rules of law I have just shared with you in the past few minutes, actually several minutes, are preliminary only. At the end of the case, I will read to you and give you a copy of the final instructions of law. In deciding the case, you must be guided by the final instructions. So just so you know, in case you decide to make any notes on your jury instructions, when right before I read you the final jury instructions, we're going to take those preliminary instructions back from you, because we want to make it be very clear that it's the final jury instructions that you must rely on when you go to deliberate. All right, counsel, any additions or corrections to the preliminary jury instructions as given to the jurors?
No.
Okay. Now, one thing I want to confirm, because I'm having trouble seeing one of the jurors. I don't mean to point at anybody, but right now I want to make sure of two things. And we're carrying several alternates, and so that's why we got so many folks in the jury box. Let me ask you right now, can all of you see me? No, not really. Okay, what about this? So this is the witness stand here to my left, and it's really important that you be able to see. I think maybe okay, you just moved over to that one juror, thank you. And for your privacy, I'm not gonna refer you by your names in open court, okay? I hope you don't think I'm being impersonal, but out of your privacy, I'm not gonna refer to your names or your juror numbers. All right, so we had one juror kind of move a little bit. Can you all see me? Nodding the heads. Raise your hand if you can't see me right now. Okay, and then this screen over here to my right, can everybody see the screen? Okay, so one thing I'm going to let you know is, so like on the witness stand, a concern I'm having right now is the people that are on my far left. You need to see the witness face on. So I'm going to work on this. We'll work on this before any witness takes the witness stand. We may reconfigure some things, because it's very important that you all get to see a witness facing them when they're testifying. But right now, I think we can go ahead and do openings, and we'll reconfigure how the jurors are sitting. As long as because you can all see the screen, you can see, this is called the well. That's what we call the well. You can all see me, you can see the screen, so that means you can see the well where the attorneys might be standing when they talk to you. So, counsel, I think we're okay for openings, but I do think I want to work on resituating jurors so that everybody can see a witness face on. So do you need to talk to me about this right now? I think we're okay to go ahead and do openings.
I agree, Judge. I agree with openings, but I do want to address that.
We'll address it. I didn't really, I didn't notice it until we had everybody in this morning. So we'll work on that, and we can figure it out. Don't worry. All right, Dolly, you ready? You okay? Keep going? Okay. All right.